Fraudulent use, possession of identifying information, identity theft. What is this crime, and what do you need to know about it if you've been charged with this crime in Texas? Hi, I'm Jeff Hampton with the Fulgham Law Firm, and I want to welcome you to our YouTube channel. And today I want to talk about identity theft and specifically the crime of fraudulent use, possession of identifying information. By the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Now, what is this crime? People talk about fraudulent use, possession of identifying information. Most of the time you don't actually hear it called that. Most people just refer to it as identity theft. And the number one way that we see this crime in the factual situation is, let's say someone's social security number information is used improperly. Let's say someone has someone else's social security card without their consent. Let's say it's being used to open up other lines of credit or to be able to obtain information. I mean, this is the type of scenario that we see it fall under. So let's talk about this for a few minutes so that we can clear up some of the misconceptions regarding this crime in Texas. Now, fraudulent use or possession of identifying information is actually found under Texas Penal Code section 32.51. And under that provision, it says that the crime of fraudulent use or possession of identifying information is a person commits this crime if, with the intent to harm, defraud, or defraud another, that person obtains, possesses, transfers, or uses an item of, let's talk about what these items are. Number one, identifying information of another person without their consent. Or number two, information concerning a deceased person that would be identifying information of that person that if they were alive, like let's say, obviously someone's now dead and they're using that person's information to open up lines of credit or do other types of things with it. That's one example. And the third one is identifying information of a child younger than 18 years of age. Okay, so what do we mean when we say identifying information? Well, the code identifies that as anything that will essentially identify a person is sufficient. What do we mean by that? Examples of that would mean social security cards, financial account information, government-issued identification numbers like driver's license, passports, all of that would qualify as identifying information. Now, it also, if you mentioned, it says that having this information without someone's consent, how is that defined? Well, consent, it means that it can be literally as part of an agreement, like someone allows you to have that, say a power of attorney or something along those lines. That's fine. But it can also mean, essentially, it's defined by the penal code when we look at what consent means. But I think we all know what that means. You either had the right to have that or you didn't. If someone says that you didn't, and whether it was express or implied, it's important that you know if you have consent to have somebody's personal information. Now, what qualifies under section 32.51 as identifying information can be pretty broad as well. You can talk about information or identification numbers that, let's say your government ID, right? Let's say you've got a driver's license. It would have information about someone's name. Maybe it has information related to someone's date of birth. Maybe there's fingerprint authorization. There can actually be voice authorization, retina or iris images, electronic identification information, addresses, routing numbers. I mean, you just name it. Everything that you could think of out there that would be specifically connected to an individual. If you have that without their consent or with the intent to defraud or harm someone, it could be a crime. It definitely would be, and a felony crime. So, how does the state of Texas prove the element of intent to harm or defraud another? Under Texas Penal Code section 32.521, it says that there is a presumption of intent to harm or defraud another person if that person possesses, number one, the identifying information of 3 or more persons. So if someone's holding 3 or more person's personal information without their consent, there's a presumption that it was being used to harm with the intent to harm or defraud. Or number 2, identifying information of 3 or more deceased persons, or identifying information of 3 or more persons or deceased persons. So what I mean is, basically, whether someone's dead or alive, doesn't matter. If you've got 3 or more persons' personal identifying information, their social security cards, their driver's license, their bank information, there's going to be a presumption that you had the intent to harm or defraud under Texas law. Now, let's talk a little bit about what is the crime of fraudulent use or possession identifying information? What does that carry in terms of a penalty in Texas? Well, under Texas law, it's a felony. And if the number of items obtained, possessed, transferred, or used is less than 5 items, then it would be looking at a state jail felony. And a state jail felony is punishable by a minimum of 180 days in jail, up to 2 years in prison, and up to a $10,000 fine. If the number of items is 5, but less, not more than 5, but less than 10, you're looking at a third-degree felony, punishable by a minimum of 2 years in prison, up to 10 years in prison, and up to a $10,000 fine. If the number of items obtained is 10 or more, but less than 50, okay, big gap right there, you're talking about a second-degree felony, punishable by up to 20 years in prison, and up to a $10,000 fine. And finally, if you have 50 or more, 50 or more unique identifying information from under the statute, you could be looking at a first-degree felony punishable by up to life in prison and up to a $10,000 fine. All right, so these are just a few things that I wanted to cover with you, because here's the thing. Let's say, look, I think we all agree identity theft's not a good thing. Being, fraudulent use or possession of identifying information is not a good thing at all. But what if you were wrongfully charged? What if someone is claiming you did this and it wasn't you, it was someone else? This is even more of a reason why you need to get out in front of your legal defense as quickly as possible. Because in the state of Texas, every felony must be indicted by a grand jury. You need to work very closely, hand in hand with your criminal defense attorney, to provide, number one, go over the evidence, and then provide information that might help show, let's say you had an alibi, let's say you can show that the information they're looking at is not accurate because of something that you have. That information can be used to make a presentation to a grand jury. Your attorney, particularly in Texas, can provide an evidentiary packet to the grand jury, and that grand jury could potentially lower the charge down to a lesser charge, down to say a misdemeanor, or they could no-bill the case altogether, which would essentially exonerate you from the charges and provide you the eligibility in the future to have the arrest completely expunged from your record. Now, maybe you haven't been arrested yet. Should you talk to a detective? What if a detective is calling you, wanting to investigate you about this? What should you do? Well, I will tell you this. You have a Fifth Amendment right not to speak to him, and you have a Sixth Amendment right to hire an attorney to help you with it. Everything you say, particularly when you're innocent, can be used, twisted, or just misinterpreted by the detective to use as a way to try to create a statement or a police report that makes it look like you've confessed to something, okay? Now, if you hire an attorney, your attorney can convey that same information to the detective, except it's now all hearsay. So if it comes from your lawyer, it's hearsay. If it comes from you, it can be used against you. It's another reason not to take the risk to trust and put your future into the hands of a detective who is not going to presume you innocent. The detective will likely have already done most of their investigation before they ever reach out to you and have already formed an opinion. So it's even more of a reason why it's important that you hire an attorney before you get to that stage, okay? Now, maybe you or a loved one is facing the crime of fraudulent use or possession of identifying information in the North Texas area. I want to invite you to contact the Fulgham Law Firm. You'll see the number that's up here at the top of the screen. Feel free to give our office a call. We'll provide you a free case analysis, a free consultation, and listen, maybe you've got some questions, and before you call that detective, you need to speak to an attorney. All right. By the way, I promised you a free ebook. You waited around to the end of the video. Click down into the YouTube section portion of the description, and I'll be happy to send you over a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Thanks for joining us here today, and we'll see you on our next video series.